Good afternoon, everyone. My name is Alexis Alvarez. I'm Director of Statewide Training at Florida Legal Services. I'm very excited to have you all here today, not only because of the content of what we're going to be discussing, but the two distinguished speakers that we have with us. So welcome everyone to When Victim Clients Commit Crime, an Introduction to Immigration Consequences of Common Crimes. As always, I'm going to start with a little bit of housekeeping. First and foremost, this is being recorded. A copy of this recording will be sent to all attendees and registrants. This also was approved for CLE credit. I will be announcing that CLE code at the end of the presentation and putting it into the chat. And it will also be included in that follow-up email that you will receive with a copy of the recording. Last piece of housekeeping announcement, because I don't want to keep you away from the substance too long, is questions and answers. Please, please, please introduce your questions and answers through the question and answer box, the Q&A. If you do put them into the chat, we'll try our best to funnel them there, but our preference is the Q&A. Put those questions in as they come up, as they come to your mind. If it's something that we can address in live time or relevant to the subject matter, we will. If not, we will address everything at the end if time permits. And so with that being said, I'm going to move into introductions of our speakers here today. Today with us, we have Mary Kramer. Mary Elizabeth Kramer has been practicing immigration law in Miami for over 28 years. Ms. Kramer is a past president of the American Immigration Lawyers Association South Florida chapter and is the past president of the Board of Catholic Legal Services. She is a 2001 recipient of the Attorney General's Meritorious Public Service Award for involvement in establishing a pro bono project serving South Florida's poor in deportation proceedings before the Miami Immigration Court. Ms. Kramer has been an adjunct professor teaching immigration law at the Florida International University. She is a frequent speaker at conferences across the United States, lecturing on the immigration consequences of crime. Ms. Kramer also has published a law book entitled The Immigration Consequences of Criminal Activity, a Guide to Representing Foreign-Born Defendants, now in its 9th edition. Also with us here today, we have John Guyon. John is a board certified attorney by the Florida Bar in Immigration and Nationality Law and has been practicing law for over 20 years. John is the two-term past chair of the American Immigration Lawyers Central Florida chapter and immediate past chair of the Florida Bar Immigration and Nationality Law Board Certification Committee. He previously served as a senior attorney with the U.S. Department of Homeland Security, Immigration and Customs Enforcement. In that role, he handled all forms of removal and deportation proceedings, including those involving aggravated felonies, drug trafficking, national security, and human rights issues, and more. He currently focuses his practice on immigration litigation, both in immigration and federal court, and has appeared on national and local television to talk about immigration issues and criminal cases, including multiple live appearances on the Fox News Network, national TV show Fox and Friends to discuss immigration, border security, and national security issues. And so with that being said, I'm going to turn over this presentation to our amazing speakers that we have here today. Thank you, John. Thank you, Mary, for being here. And thank you, audience, for coming and learning with us today.
Thank you, Alexis.
Thank you very much, Alexis. Well, I want to say, first of all, it is my honor and pleasure to be on a panel with Mary Kramer. She's absolutely amazing. I'm really just here to kind of to guide the ship a little bit. I know all of you want to hear from her because of the fact that she's the expert in this area, and I am just happy to be along for the ride, and of course to read her book. And because that's really what you need for all of this. Today, we're going to do a lot of issue spotting and kind of just getting under the surface. This is not a super advanced panel on all aspects of immigration law. This is, going to be a rather shallow dive across a very wide pool. If you want to get deeper into things, that's what Mary's book is for. So how you doing this morning, Mary?
I'm great. Thanks, John. I just, I want to say and shout out to Alexis. It's an interesting topic, right? I mean, you and I speak together a lot. We speak all over at different places. And this is the first time I have really honed in on this particular topic and this issue. And it's really, really important. So it's a cool nuance of immigration and criminal law. And Alexis, we don't have your beautiful face anymore, but I want to say thank you because it is an important topic and it's an interesting topic. So you nailed it.
Thank you very much. I'm so happy to learn from you both.
Right. And as Alexis told you, feel free to put questions into the Q&A at any point. We're not going to stop our presentation necessarily to get into a question, but sometimes it can be a wonderful segue from one topic to another or a place filler as we see fit. So if you have a question, throw it into the actual Q&A. We might answer it live. We might just type you a response. So with that, I think we should get started. Happy Fat Tuesday for those of you who celebrate. It's going to be a great excuse to eat beignets and to drink too much tonight before we feel bad about it tomorrow morning. And of course, go to mass and get your ashes. So with that being said, not a holy day of obligation, which you would think it would be, but it's really not. So so those of you who are Catholic, you don't have to go, but whenever you go to church and get something and leave with it, most popular days, right? Palm Sunday, you get to leave with the palms. Ash Wednesday, you get to leave with the ashes. People love that. It's like
Yep.
it's like marketing. It's
True.
like a tchotchke for the church. But
Any
that's
priest
neither-
will tell you that the minute they give away a palm
Right.
or some ashes, everybody's there. Yay.
Absolutely. So with that, let's go ahead and get started. We're told our audience today is quite a wide swath of individuals in different practice areas, but everybody has an interest in the victim slash client who commits crimes, is a victim of a crime themselves, and how that interacts with immigration law. So one of the first things, and I know Mary does this all the time at a much higher level than I do, but what we often deal with are criminal defense attorneys who come to us, and the first thing they're going to say is, hey, I got this lady or I got this guy. Here's what the charges are. What are the immigration consequences? And usually the first thing I need to know is, well, what is their status? Why is the person's status important, Mary? And what does that even mean?
Well, there are 2 chapters in the immigration law, not 3, not 4, not 10, don't worry, but 2 chapters that you generally need to be aware of and check when you have a client charged with crime. And what chapter applies is going to depend on your client's status, your client's immigration status, your client's physical posture in the United States. So you're not going to go to the right chapter unless you initially, out of the box, in your office or in jail, ask your client, how is it that you are here? Are you a permanent resident? Did you cross the border illegally? Did you come on a tourist visa, change to student, but now you're undocumented? Maybe you're documented. There's a lot of different ways that a person can be here. And you need to be able to determine what chapter you're going to look to in determining what are the immigration consequences of that charge that they're facing. So do you want to do 212 or would you like me to?
We can do it either way. I think a little bit of a primer also is we use acronyms within immigration law because in the federal government, we always love acronyms. When I started with ICE, I don't know, about 15 years ago now, they give us a list of common acronyms we had to memorize in order to understand the daily life. And so many times the acronyms were exactly the same and they meant different things, which of course is a lot like immigration law where it's completely counterintuitive. So when we're dealing with an acronym like the INA, as you can see on this particular slide, it's the Immigration and Nationality Act, most of which is found at 8 USC, that's United States Code, and then some subsection. So the first subsection that we're going to talk about, as Mary says, which chapter are we going to talk about, is 212. So Mary, what types of clients would fall under 212 and as far as their designation and how they are here in the United States?
All right. And I should mention section 212 and 237 have significant overlap. They are similar, but they are not the same. All right. So clients who are appearing at the border, crossing the border illegally, coming in at the airport and knocking at the door, but they're not in yet, are going to fall under section 212. Also, a lawful permanent resident, green card holder, 30 years, I've got my green card, or I've got an investment visa, I'm golden, all right? If they are coming back into the country from abroad, knocking at the door, at the airport, at the seaport, they are also going to be subject to scrutiny under Section 212. I will also mention, and we will talk about this a little bit, but we could talk about this topic all week long, and we don't have that much time. We will touch on waivers, otherwise known as defenses or relief. Eligibility for the waivers, meaning the client has been found deportable, but now they're seeking, a pardon, a waiver, residency, some kind of defense against the deportation. The criteria for the waivers is generally found at Section 212.
Okay. What about people who have crossed into the United States without being inspected or paroled, or people who, the normal nomenclature would be, oh, I'm here illegally. Not someone who entered legally, but someone who entered without a visa. Would they be under this category too?
12.
Okay,
Yep.
all right. And this is really important to understand, because as we get further into this presentation, you're going to see that there are completely different reasons why someone can be deported from the country, depending on whether you classify them under 212 or 237. And when I do these presentations, I always tell everybody, it would seem to make sense that someone who doesn't have any status in the United States, or someone who's trying to come into the United States, we'd have a gigantic plethora of reasons to keep them out. And so there should be a gigantic list of reasons to keep people out of the US or to deport them if they are here without, proper documentation. However, it's just the opposite. People who come legally have 1,000 different ways you can deport them, but people who do not come legally have very limited reasons why they can't be deported, but it's all important. So with that being said, let's talk about the other subsection of people who are here in the United States. Those who entered legally, they fall under INA Section 237. For those of you who saw the word arriving aliens and felt a little bit of a triggering mechanism, I apologize. I tried to change the statutory text as much as possible and get rid of the word aliens and replace that with clients. However, arriving aliens is such an important term of art. I left that one in place. If I missed some others, I do apologize. But arriving aliens is a really, really important distinction. So that's something everybody should be aware of. So back to 237, non-immigrant. When we say non-immigrant, these are going to be people without green cards, people without lawful permanent residence, people who are coming to the United States for a limited purpose and a limited period of time. These could be your tourists, your people who are coming for a small business venture to do some, quick work, who are not employed here. It could be people who come as students, people who come as performers. There's a whole host of non-immigrant categories that people come to the United States under, and everybody who is lawfully admitted to the United States in one of these categories is then subject to the 237 chapter and those grounds of removability. This also applies to people who already have their green cards. So whether you came into the United States and applied for something called adjustment of status and then obtained your green card, or you entered the United States as a lawful permanent resident, which are two different ways to do it, both of those people are going to fall under the 237 chapter. So this is really important to understand this as we move forward, because you're going to see INA Section 212 and 237 throughout these slides, and now you need to know which one applies to what. So
one important distinction, I think, John, is generally speaking, I think you're better off under 237, although your point is really well taken that it's a long list. But under 237, you're going to need to have a conviction. Under Section 212, if you admit the essential elements, confess, we'll say, or there's reason to believe you've been involved in drug trafficking or money laundering, you can be found inadmissible without having a conviction. So I think the fact that you need a conviction is more of a protection for people who lawfully came into the United States. Now, that being said, I'm going to throw out something that everybody knows, right? Because by now in Florida, you should all know this. A withhold of adjudication is a conviction, same as if you went in front of a 12-person jury and you were there for 6 months before they convicted you and sentenced you. So a withhold of adjudication is not going to be a disposition that saves the client, the non-citizen client. The other thing is even pretrial interventions, drug courts, pretrial diversion, if there is a plea involved at the front end, you're going to have a conviction, regardless of a subsequent vacatur of the plea.
Right. Yes, very, very important distinction. That's one of the main things that we try to cover with criminal defense attorneys and anyone who's interested is the withhold of adjudication doesn't help you. PTI, pretrial diversion, may not help you. Drug court, mental health court, any of these courts where you're going before the judge to try to get some sort of diversionary process, those could all lead to convictions, not in real life, but for immigration purposes. And so what we often tell people is the best time to engage an immigration attorney to help with a client who has been arrested is as soon as they are arrested, because you can't get unarrested. There's going to be negative immigration consequences no matter what, as soon as you are arrested. So it's just a matter of how severe they are. How do you mitigate that arrest? Because expunging that arrest, even if your case is ultimately disposed of and dropped, expunging that arrest does not erase it for immigration purposes, and you're still going to have to disclose that. So you might as well get ahead of the game and try to mitigate the damage. Because we're going to talk about a lot of the grounds to keep people out of the United States and deport them while they're here. But towards the end, we're going to get into special categories like TPS and DACA, you know, for the dreamers and good moral character. And these are all sections that they don't require a conviction to be used against the person. And some of them, it doesn't matter what you're convicted of. It could be anything, and it could be a negative immigration consequence. So it's really, really important. So let's get into the kind of common grounds of inadmissibility and removability under the Immigration and Nationality Act. Mary, let's talk about the first one, crimes involving moral turpitude, which does not sound all that concrete. So what is it about? What is the CIMT? What are we looking for? You know, how is this going to affect our clients?
So crime involving moral turpitude is a phrase that's been around for like 100 years in the immigration law. And it's determined based on case law, actually, case law that looks at the particular crime that has been, you know, charged and prosecuted in the past. But there's always room to make good meritorious arguments that a particular conviction is not a crime involving moral turpitude. You do look at the elements, you look at the elements of the criminal statute. You are looking for knowledge, a culpable mental state, and then reprehensible conduct. Now, how you want to define that, you know, I don't know, right? This is why we get paid to represent people, because every new case invites a new argument. But reprehensible conduct is essentially wrong by any society's standards. So a blatant fraud based on the elements, intentional violence with bodily injury based on the elements, not what happened, not the facts, not the arrest reports, but always based on the elements. Money laundering, when the statute involves knowledge of the underlying criminal proceeds, moral turpitude. Any type of intentional sexual abuse of a child, or, you know, any type of rape offense, it's going to be a crime involving moral turpitude. It's sort of like the 10 Commandments. We all understand in every society that this is something you do not intentionally do. That's moral turpitude.
I like that. I haven't heard that one before, the 10 Commandments one. Yeah, the way we look at it often is it the old Latin terms that we had from law school? Is it malum in se? It's just wrong because we know it's wrong intrinsically, or is it malum prohibita? It's wrong because of the fact that the government has decided to regulate that particular area of action and make it illegal. So quick example, Mary gave you all the examples of things that can be crimes involving moral turpitude. Regulatory offenses, as we call them, like driving on a suspended license. You know, no one ever said that that is just intrinsically wrong. It's wrong because we regulate drivers. You knew you were suspended, therefore you shouldn't be driving. That's not a crime involving moral turpitude. So we still can have negative immigration consequences. So CIMTs can be used against individuals, whether you're in 212 proceedings or you're in 237 proceedings. So whether you are here legally or not, you can still have a crime involving moral turpitude held against you. And as Mary said, if you see this definition here, people who are entering the United States or who are here without status, they can have this ground of removability or inadmissibility, as we call it, put against them in immigration court or before USCIS, which is the benefits arm of the federal government. You can have this brought against you even if you didn't get convicted. If you admit the essential elements of the offense, or you admit committing the offense, you can still have this held against you. There's a few different exceptions and caveats, and there's some rules and go-bys as far as when an admission counts against you and can lead to this ground of inadmissibility. But remember, anytime someone is charged with anything that could be a CIMT, you've got a potential serious immigration consequence. Now, under 237, it's slightly different. So, it just depends. When did you come into the country? What's your immigration history? When did you commit the CIMT compared to when you entered? How many do you have? What was the possible sentence that could have been lodged against you? And again, we're not getting too deep into these grounds of removability, but you definitely can have some different consequences for a CIMT depending on how you entered the United States. So, knowing your client's immigration history and their background and the dates and their status is extremely important for advising on these areas. Okay, so CIMT, now we move on to firearms. Firearms are going to be grounds of deportability only under 237. So like we said before, there's only a handful of reasons you can keep people out of the United States for crimes or criminal activity. But if they're here and they entered legally, they can be deported for pretty much any crime, any conviction involving a firearm. So whether that is potentially carrying a concealed firearm in Florida, that's a problem. Discharging a firearm in a residential area, that could be a problem. So any crime that has an essential element, that is, it is required that a firearm be involved, can in fact be a deportable offense. There are a couple exceptions under Florida law. When we're dealing with immigration law, as we talked about, that is federal law. And so the guidance that we receive for all of these grounds of inadmissibility and removability are all rooted in federal law. So when we're deporting people for possessing or doing something illegal with a firearm, we're using the federal definition of a firearm. So in certain circumstances and in certain crimes, if your definition of a firearm, and let's say the state of Florida does not match the federal definition for a firearm, you might have an exception. You might have something that's not a removable offense. Right now, we don't quite have that. There's plenty of arguments that can be made that our definition in Florida does not meet the exact definition of a federal firearm, but we haven't quite perfected that yet, even though many very intelligent immigration attorneys and very skilled litigators are working on that, mostly out of Miami. But in Florida, one of the big exceptions, and I know this seems crazy, but carrying concealed firearm, deportable offense. Possession of a firearm by convicted felon, not a deportable offense.
Not a deportable offense. And I think,
Right.
I think that's even worth repeating. And that's a fairly new development in the litigation landscape, a decision out of the 11th Circuit Court of Appeals. But the Florida felon in possession of a firearm statute is much broader than the federal definition of firearm, because a felon in possession of a firearm can include things like ammunition and goes beyond how federal law defines firearm. Whereas carrying a concealed firearm, as opposed to carrying a concealed weapon, carrying a concealed firearm per se has been found by the 11th Circuit to pretty much match the definition of the federal offense. I also want to say, John, by the way, just by way of example, a firearm offense would not be a crime involving moral turpitude because it's something we regulate. So I think firearm is a great example of what is not a crime involving moral turpitude. It has its own shoebox under section 237, does not exist under 212, which means when you're applying for something like adjustment of status to permanent residency, the firearm conviction per se is not going to be an impediment to the application for permanent residence. A lot of permeations, which is why we say, and I'm going to say it again, your first question out of the box, what's your status? How are you here?
Mhm. It's really important to understand. Now, as I said, USCIS is our benefits branch of the Department of Homeland Security, and they deal with immigration. You try to explain to them that a firearms conviction is not something that will, bar or prevent you getting a green card, and it blows their mind. They're like, no, 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 no. You can be deported for this. I say, yes, you can,
Yeah.
but you can't be denied your green card solely for this. At least not because of an inadmissibility ground. I don't need a waiver. Sure, it's an extreme negative discretionary factor. And that's another thing to remember with every form of immigration benefit. Is every form of immigration benefit, with very, very, very small exceptions, is a discretionary benefit. So you might be absolutely qualified for a green card, for TPS, for a whole variety of immigration benefits. But if the government decides you don't deserve it, you don't merit a favorable exercise of discretion because of your terrible criminal record, most of these things can be denied for that. And so this is not a situation where you can just go out and violate the law, as long as you make sure that the convictions you have meet certain little boxes for which you can't be deported. Everything goes into good moral character. Everything goes into discretion. It's something to look out for. Another common area.
Oh, sorry. Now that you've seen this, defense attorneys, do not take your charge of convicted felon in possession of a firearm and try to plead it down to something else. Leave it at convicted felon in possession of a firearm, because it's essentially now a free pass.
Right. Yeah, it's counterintuitive, but most of immigration law is. Mary's absolutely right. So if you're dealing, and it's also important to remember that not every felony, just because it's a felony, is something that's going to get your client deported. So if you've got a green card in a grand theft conviction, and then you pick up a possession of a firearm by convicted felon, these are some pretty serious felony convictions, but it doesn't mean your client's going to be deported. So get that immigration attorney involved as soon as possible in your cases. Now, the next section we're going to get into, I'm sure, is near and dear to everyone's heart, and a lot of what you're looking at.
Yeah.
Domestic violence. This is an area of the law that most of our clients who end up being victims are often going to be victims of domestic violence, whether they're also accused of it, arrested for it, and involved in it. That happens a lot. We all know there is a cycle of violence that happens in a lot of these relationships. And one day someone is battering one person, the next day you're battering another person. Sometimes these things are completely made up as retribution. So domestic violence permeates a lot of what we deal with, and we need to know what are the immigration consequences. So what is domestic violence for immigration purposes, Mary? What are we looking at?
Well, first of all, the domestic violence, what I'll call shoebox under Section 237, does not exist under Section 212A. Again, there's overlap, right? So an act of significant domestic violence, child abuse, stalking, it might be a crime involving moral turpitude, right? And it would make you inadmissible under Section 212. But the per se words, the actual words, crime involving domestic violence, stalking, child abuse, and violation of protective orders, violation of injunctions, even civil injunctions, is a big paragraph under Section 237, which we now know applies to persons who were lawfully admitted into the country, right? So as we all know, Congress takes domestic violence and child abuse very seriously. This provision was added in 1997, and it is a wide net. So do you want to go to the next slide, or do I keep?
Yeah. No, I mean, this is a controlled substance.
Okay. So let's go back to domestic violence. All right.
Right.
So basically a crime, and we'll get more into specific Florida statutes coming up, right? But basically a simple battery under Florida law is not going to trigger a crime involving domestic violence. The way the statute, the immigration statute is written, it does have to be an enumerated victim, which you all know under federal law, and many, many states will say a spouse, a former spouse, a former or current cohabitant, or a person that you have a child in common with. That's kind of a universal definition in the United States, but not in Florida. Florida actually does not have a per se domestic violence statute. The police can stamp the arrest report domestic violence. There are sentencing provisions that are focused on domestic violence, but we don't have a per se domestic violence statute with an enumerated victim. So except maybe one of the statutes that is more serious than simple battery, the strangulation. So simple battery involves a touch or a strike. It's not going to meet the definition of crime of violence, which is a requirement under the domestic violence statute or provision. And it doesn't have the enumerated victim. Now, by case law, which I disagree with, and I argue against, an immigration judge or adjudicator is able to hop outside the categorical elements of the statute and look at other documents in the case to determine whether it was a specific domestic violence victim. That's called a circumstance-specific approach, where you hop outside of the statute. I disagree with that. I always argue with it, and I don't think the 11th Circuit has spoken to that issue. But we don't have a per se domestic violence simple battery statute. Stalking, any kind of stalking, the child abuse net is dense. Even simple child abuse where there is a mens rea of negligence or just neglect, passive neglect, that's going to be child abuse. And the child abandonment, all of those kind of passive crimes where you really didn't have the intent to hurt the child, that's going to snag you under 237 A2E. It's the view, John, is take no prisoners. And the judges are tough on this, and the Board of Immigration Appeals, our administrative appeals unit, very, very tough on this. And by and large, the circuit courts of appeal across the country defer. They show deference to the agency decisions.
That's right. And we're going to get more in depth into these areas and apply them specifically to Florida law pretty soon. But this is just kind of an overview of the general ones that we're going to be covering. So next, and this is a huge area of grounds of inadmissibility and removability, are going to be controlled substance offenses. So this is one area that overlaps, kind of like the CIMT. You can be kept out of the country for that. You can be deported from the country for that, 237 and 212. Same thing with controlled substances. You can be kept out of the country for this, and you can be deported from the country for this with certain exceptions and requirements. Now, until about, about a year ago, I would say the 212 grounds of inadmissibility. So this would apply to everyone coming into the country, even if you have a green card. You go on a cruise, you haven't left the country in a long time, you're coming back into the port, all of a sudden they pull you aside at inspection and go, hey, do you have a misdemeanor weed conviction when you were 19? Well, oh yeah, I just got a ticket, I paid it, no big deal. Yeah, come with me, you're going to immigration jail. Like, wait, what? Up until about a year ago, that's what absolutely could happen, and it happened all the time. People do a short, innocent travel abroad, and they come back, and something in their past, which never bothered them before, gets brought back up. It could be even misdemeanor weed. Now, thanks to a wonderful 11th Circuit case called Saeed versus U.S. Attorney General, remember how we were talking about federal definitions versus Florida definitions? For firearms, we're still pretty aligned, unfortunately, but for cannabis, we are not. So the 11th Circuit has determined that in pretty much every immigration context that is going to be useful to us, Florida cannabis is way overbroad compared to federal cannabis. And so your cannabis convictions, withhold or not, are not going to be grounds of inadmissibility anymore or deportability simply because it's cannabis. And we'll get into some exceptions to that also. But typically speaking, cannabis is going to be safer than every other federally controlled substance.
Free pass on marijuana. For those of you who want to remember the Syed case, it's spelled like said, okay? He said, she said, John said, Barry said, wasn't either of our cases. But anyway, we were saying it long before the 11th Circuit decided, right, John? So
that's right. That's right.
And
we said it.
For you marijuana scholars out there, and I know there are some of you out there listening, in 1979, the Florida legislature changed the definition of of marijuana, of cannabis, and just really, really broadened it because it was just so difficult for the police and the lab people to figure out what was active THC and what was just like a sterile seed, and then what was maybe the dirt. Let's weigh some of that too, a broken piece of pot, right? Meaning the clay pot. So anyway, the Florida legislature in 1979 expanded the definition to include everything in the kitchen sink to make it easier for labs to weigh and to prosecute these cases. Well, under federal law, as you all know, 0.3 THC is the dividing line, and it has to be a portion of the cannabis plant that is active and can actually get you high. So now listen up, drink some coffee, and pay attention. Trafficking crimes in marijuana can still be crimes involving moral turpitude because there is a body of case law that says trafficking, and that's your import and your manufacturing, etc., can involve moral turpitude. Same 11th Circuit Court of Appeals. Go figure. It's not my fault, not John's fault. 11th Circuit, different panel. So you might still have a moral turpitude problem with a trafficking type conviction for marijuana, but otherwise, marijuana free pass.
That's right. That's right. So just remember that Florida cannabis, you're not going to really have to worry about that anymore. We're still fighting about that, and some offices, some USCIS adjudicators are still trying to require waivers and the like, or denying people for that. But generally speaking, you're going to be fine with cannabis. Every other federally controlled substance, no. So any substance in any amount that's federally controlled is going to trigger this 212A2 ground of removability. I'm sorry, of inadmissibility. So every other controlled substance, even if it's a prescription drug for which you don't have a prescription, you get busted for that simple possession. 893, what is it? 103, 89303. I think is what the definition are. I used to have all these memories. No, 6A. Sorry, 893.136A. That's going to be something that's going to trigger your inadmissibility. Now, the deportability used to be slightly different because you used to get one misdemeanor weed for free, and then you could be deported for everything else. Well, now everybody gets that weed for free. So the ground of inadmissibility versus removability are now pretty much the same. Any federally controlled substance can get someone deported. So you really almost, I would say, don't have to ask an immigration attorney if your client is charged with some sort of controlled substance, but yes, you need to ask because there are ways around that. There are drugs in Florida which are not federally controlled, and if you can somehow convince your courts to plea your client out to that drug as opposed to a federally controlled drug, you might be able to escape some immigration consequences, but you're going to need some help with that. So
And
controlled
John,
substance is very important.
I want to say, but I want you to tell me if you disagree. I think generally you are okay with paraphernalia convictions, even if it's not a marijuana type paraphernalia. I don't think that the Florida paraphernalia statute and the definition of paraphernalia is a categorical match to federal law. So, if you're in front of USCIS, which is not as sophisticated as immigration court, you might have to, hand in a pretty good legal memo on why paraphernalia is not a controlled substance offense. But I think we're okay with paraphernalia, but I don't know what you think.
I think we are too. I have seen some creative government attorneys trying to link the paraphernalia conviction to an actually federally controlled substance going outside the normal record of conviction that would be used in immigration court. And some of your overzealous judges will agree with them. But generally speaking, paraphernalia should be safer than fleeing out to just possession of cocaine. Nothing is a free pass, nothing is set in stone. And there's one thing about immigration law that I've learned is, everything could change tomorrow. I mean, literally, we could get a decision that comes out tomorrow that changes all of the advice that we give. So whenever I give advice to criminal defense attorneys, the first thing I put on there is, as of the date of this email, this letter, this memo, based upon the current laws and current interpretation of policy, this is my advice. Because again, these things can change on a dime, and a lot of times they don't stop the retroactive effect. Meaning, if our 11th Circuit comes out tomorrow and decides, oh yeah, grand theft, that's always been a deportable offense, even though, nobody's been deported for that in Florida for forever, but it's always been a deportable offense. We've just been interpreting it wrong. And then suddenly every grand theft conviction, which we said was totally fine, not anymore. So we have to remember that is nothing is ever safe forever. And there's no statute of limitations on immigration law. They can come back at any time they want for any 1960, 1972 conviction and try to deport people for them. It's pretty crazy. All right. Controlled substance offenses. Those are just the simple controlled substance offenses. There are more complicated ones, which we will get into under the aggravated felony section and the other sections, but those are the pretty much the simple ones. Aggravated felonies, Mary, that's quick and easy, right? Can you cover that in like 30 seconds? What do you think?
Done.
All right,
Aggravated
good.
felony is a big shoebox. And it sounds bad, right? Like aggravated felony. And when the term was first introduced by Congress in 1988, it included like 3 crimes, like international firearm trafficking, murder, and rape, right? And it is just like grown and grown until the point where I really don't think an aggravated felony is necessarily a bad thing. So it's kind of a misnomer, but it is the most difficult immigration shoebox to be in. It can trigger bars. It triggers deportability, not inadmissibility, deportability under 237. It does require a conviction. It does not necessarily require a felony conviction. Most of the time, it has to be a felony, but there are certain things like smuggling and sexual abuse of a minor, people smuggling, human trafficking, that does not even necessarily need to be a per se felony. And by the way, felony is a term of art based on federal law. So any client after admission who has been convicted of an aggravated felony is going to be removable and barred from several forms of relief. There are, now I know this thanks to John in the PowerPoint, 21 categories. I never really stopped to count, but it is significant crimes of violence where there is a term of imprisonment imposed of at least 1 year, crimes involving fraud or deceit, where the loss to a victim exceeds $10,000, which is like not very much, right? Crimes involving tax evasion under the IRS code, where there is a loss to the IRS of $10,000 or more. Theft crimes, and we're going to talk about Florida theft. So this is a huge caveat. I don't want to confuse you. Florida theft is basically a free pass, but thinking about other states, a theft crime or possession of stolen property where the term of imprisonment is at least 1 year. Rape, regardless of the sentence, murder, regardless of the sentence, sexual abuse of a minor, including pornography, regardless of the sentence, passport crimes. So it is a long list. It is defined at 101A43. And the best way to figure out whether your client is facing an aggravated felony is to take your finger and go to section 101A43 and just make your way down the list.
Yep. Yes, aggravated felonies are the worst of the worst. This is ultimately what you're trying to avoid for your clients, because typically speaking, a conviction for an aggravated felony is going to bar all discretionary forms of relief, of course, except when it doesn't, because it's immigration law. So there are no hard and fast rules for sure. But just understand that it's going to be a big problem. Another example of aggravated felony is going to be trafficking offenses. These are going to be drug offenses that have a element of trading or dealing. And we'll get into that when we get more specifically into the Florida statutes, because it's, again, completely counterintuitive. And the 11th Circuit does one thing here and another thing here. Mary.
Professor Guyon, I also want to say, a lot of these crimes, but especially aggravated felony, a lot of these grounds we're talking about trigger mandatory detention. So mandatory detention is an immigration law that says if you are subject to removal, inadmissibility, or deportability for crime, you are going to be mandatorily detained, no bond. There are a couple of exceptions. The domestic violence ground, for example, does not automatically trigger mandatory detention. One crime involving moral turpitude, if you were sentenced to less than a year in prison and you're charged under 237, doesn't trigger mandatory detention. But criminal attorneys tend to forget immigration mandatory detention, and they think, oh, we got probation for the client, what a great deal. Well, then they're going to do 6 to 8 months in Baker County ICE custody or at the Chrome Detention Center, and it really wasn't such a great deal. Sometimes criminal attorneys will negotiate 366 days in jail so that their client can qualify for good time credit. Whereas if you had negotiated or just agreed to 364, they wouldn't have been mandatory detention.
Right.
So that's an important consideration.
Right. It's a huge concern also. In addition to that, we have concerns about detainers, which flows into mandatory detention. Those of you who do criminal defense or have done it, you know, when someone's in custody and maybe they might have status, but they're charged with a serious crime, or they don't have any status, they're going to get a detainer put on them more than likely by your local, friendly neighborhood ICE officer in the jail. A lot of times we get calls, well, we want to have this lifted, well, okay, good luck. Because until that case is over, until the person is ready for release, ICE is not going to even look at the case, and they're certainly not going to entertain any sort of mitigation for why they should lift the detainer. They're going to keep that detainer on because they are afraid of screwing up, and they're certainly afraid of Governor DeSantis coming after them. So we have to remember that. But it's true. And again, one thing to remember is not everybody who has a detainer is deportable. I've seen plenty of times where lawful permanent residents who do not have any other convictions are charged with a pretty serious offense, could be an aggravated felony, but they haven't been convicted yet. They're trying to bond out. They've got that detainer and they're like, should I bond out? Should I not? And as long as they're not deportable, you might be safe bonding them out because they're probably going to be released because they cannot be detained until they are deportable. Now, the other side of that is, yep. And the other side of that is anybody who's here without status is deportable no matter what happens in their criminal case. So you might get the case dismissed. You might think, oh, I'm going to bond them out. They haven't been convicted yet. ICE won't bother them. Well, yeah, they will. Yeah, they will, because they don't have any status. They're likely to go straight into custody, and so that's always a concern. Yep. All right. So as usual, we're not quite keeping up as quick as we thought we would. So categorical analysis, we could spend 45 days on this particular section, and Mary is unbelievably great at it. But the categorical analysis, for those of you who have done, let's say, federal criminal defense work, this comes into play when you're dealing with sentencing issues. And so that would be your corollary if you don't do immigration work. You are analyzing statutes to see if these are serious drug offenses, if these are crimes of violence. And we do the same sort of thing in immigration law, is we need to look at the statutes themselves and figure out whether or not these are deportable offenses under 212, 237 and the like. So Mary, how do we do that?
Well, I always open up the book or go to Lexis and pull out the statute, and I'm looking at the essential elements of the crime, and I'm hoping that the statute is not divisible. If the statute is divisible, meaning that because of the way it's written, it really includes more than one offense, then you have to determine which offense applied in that particular case. So we want to avoid divisible statutes. We want our Florida statute of conviction to be indivisible. And then when you look at the elements, if it seems that there's different things involved in the statute, you look at the least culpable conduct. So maybe, we're going to look at battery and it says a touch or a strike, right? Well, that's been found to not be a divisible phrase. And the least culpable conduct is touch, and touch is not going to trigger an immigration consequence. There's a whole analysis for determining whether or not a statute is divisible into alternative elements or whether it's indivisible and just one solid statute. And here John has, the different formula. I think everyone's going to get the PowerPoint, and they will be able to take a look at this on their own if they need to.
That's right. Right. This webinar is not about how to analyze statutes to determine what's divisible and what's not. It's just kind of giving you an idea of why things are the way they are. When Mary says touch or strike is not a crime of violence, and then when we get more into battery, and when you look at causing bodily harm, might be both a crime of violence and a crime involving moral turpitude. This is why, because it's a divisible statute. So this is beyond what we're going to talk about today, but we just want to give you an idea of what we're dealing with here and why this isn't as simple as, hey, my client was charged with this, are they deportable? You know, you just can't answer things necessarily that way, and you got to look at the statute. So generally speaking, I try to create a list. Mary went over some of these before. In Florida, these are the types of charges that are going to be pretty much bad all the time. These are almost always going to trigger some sort of ground of inadmissibility or deportability. And another factor to remember, an important thing is a single conviction can sustain multiple grounds of inadmissibility or deportability. So you could have a crime that is both a crime of domestic violence, an aggravated felony crime of violence, and a crime involving moral turpitude. And it could be all three of those things. And you might be able to avoid the aggravated felony crime of violence by reducing the sentence, but oh crap, it's still a crime of domestic violence because the sentence doesn't matter, and it's still a crime involving moral turpitude because of their immigration history. So one conviction can be many different things. Obviously, as Mary said, murder, bad. Aggravated battery based upon the use of a deadly weapon or the amount of harm caused, bad. Aggravated assault, bad. Felony battery based upon harm caused, not based upon an enhancement for a prior conviction, is bad. Domestic battery by strangulation is one of those that can be both a crime of domestic violence and a crime of violence aggravated felony. Obviously bad. Resisting with violence, bad. These are bad things. Lewd anything. So any conviction under the 800-04s is going to be bad. It's likely going to be a crime, an aggravated felony, a crime of sexual abuse of a minor. Child abuse is a CIMT and a crime of child abuse. Child neglect is a crime of child neglect. Carrying concealed firearm, as we said. You can see the list there. These are all bad things and for different reasons. So, you know, if you want to print out that slide and have that as your giant issue spotter, hey, crap, I got to avoid these things at all costs, please do it. Ones that are not as bad, and I don't say safe, I don't say good, I don't say no problem, yay, you know, get convicted of this. These are things that are not going to cause instant problems for your client as far as, oh, automatic, you know, mandatory detention, no relief, and deportability. These are things where we might want to mitigate our arrest damage. We might want to have a chance at the person staying. And of course, it's counterintuitive because simple battery is not aggravated battery. Simple assault is not aggravated assault. Battery on a law enforcement officer is just simple battery on a protected victim. It doesn't require a weapon. It doesn't require injury. So these are all things that can be safer. Cannabis on there now, PFCF on there now. Somebody asked in the chat, DUI, what's up with that? It can be a safe harbor if you have status, but it also can lead to denial of your citizenship in the future. It can lead to all kinds of problems if you're trying to get a green card, you know, and you don't have one already, and they think that you're an alcoholic. So these are the types of things that are going to still be okay. I love disorderly conduct. That is always a go-to. If I've got to have a misdemeanor that I'm going to please somebody out to, I love disorderly conduct because it covers all gambit of possible nefarious activities.
I do want to
right.
say though, John, if people are going to print out the bad slide, it's like the mercury, you know, in the barometer going up and down, depending upon the sentence imposed, depending upon whether there is a prior criminal record, depending on whether there is a financial loss to a victim, and depending on status, there may or may not be workarounds. So if you post on your bulletin board or your bathroom mirror the bad slide, remember there's always room, there's always flexibility. And you know, John's disclaimer that, you know, everything is bad. Keep in mind, if you're working with a good immigration attorney or you're studying and doing some research, you can come up with viable solutions moving forward. And for those of you who are maybe prosecutors, I just want to thank you in advance for being willing to do that. Next slide.
That's great. Great idea. Okay, now we get into one of Mary's, how should I say this? Most loved subjects is talking about prostitution. I know that sounds terrible. It sounds terrible, but I just heard her, you know, she did a panel last week in Miami, and she talked a lot about this. And I thought it was really, really interesting. And I think this will strike this will come home to a lot of people who are here today, because we talk about the victim slash client, at the same time. And I think that this area definitely serves that moniker. So let's talk about it, Mary. Tell us
Well
about
said.
prostitution.
And we are going to get into now specific Florida crimes that we've tried to have the focus or sort of the angle of. These might be common crimes that your clients who have very much been victimized also have convictions or are facing charges. And it's sad, but life is complicated and human beings are very complicated. Wow, that's really intense. You needed me to say that, right? But no, I mean, this is a very complicated area of the law and very, very compelling and sad. So prostitution is actually its own shoebox. It's its own category of inadmissibility under Section 212A if it's commercial in nature. And then prostitution, be it that your client is the prostitute or your client is the customer, has been found, over the decades to be a crime involving moral turpitude. So to repeat that, prostitution is its own ground if it is really commercially oriented. And that's going more, I think, John, towards, the traffickers and the pimps at Section 212D. And then prostitution from either side has been viewed as a crime involving moral turpitude. But I think it's really, really important that we argue and we litigate against that point of view. I think that nowadays, with the Violence Against Women Act provisions that are, found throughout federal law and immigration provisions, our society is increasingly recognizing that very often what we would call a prostitute is a victim and is a person who's been victimized. I don't believe that. I don't believe in the phrase sex worker. I don't believe that a prostitute is an adult who's made a decision that she wants to engage in consensual sex for pay. And a lot of that is my work representing victims as a private attorney, and also just my personal moral and ethical beliefs and what I've seen. I think by and large, the prostitute is someone who has suffered a lot in life, be it drug addiction, be it child abuse as they were growing up, being exploitation. So I have successfully argued that a conviction for prostitution, being the prostitute, does not represent a crime involving moral turpitude, and that if we are going to be consistent in our approach and protect the victims of trafficking, we have to recognize that the so-called common ordinary prostitute is a victim of abuse. On the other side, the customer, normally a crime involving moral turpitude, as I said, is a crime that across the board is understood to be morally reprehensible and wrong. We have, though, a country and a world where prostitution is legal in a lot of different places. So I would argue that it is a regulatory violation, and it is not a crime involving moral turpitude. There is a fairly recent Board of Immigration Appeals decision, though, that hiring a prostitute, soliciting a prostitute is a crime involving moral turpitude. It was a Minnesota statute. So if you are a prosecutor and you represent someone charged with prostitution, take a good hard look at the overall situation and decide whether or not you really want to go for that conviction. If you are a defense attorney, understand it could raise deportability. And if you are an immigration defense attorney, do not let me find out that you did not argue and litigate that a prostitution offense is not a crime involving moral turpitude, because it's not a crime involving moral turpitude, and there's very good arguments to be made. Our laws cannot be internally hypocritical. We can't say, well, in one case, she's bad, but in another case, oh, poor thing, let's protect her with a T visa or some sort of witness protection. We need to be consistent, right? So that's pretty much what I wanted to say about prostitution. Commercial prostitution, being in the business of prostitution, sex trafficking, aggravated felony. Those are aggravated felonies.
Yeah, it's one thing to remember too, is there are immigration benefits for victims of crimes. And
Mhm.
I can't say that I know a lot of people who have engaged in prostitution throughout their lives, but the ones I do know, almost every single one of them would qualify for a U visa, because at some point during their life, whether it was when they were children or during, you know, the actual employ as a prostitute, they are victims of crimes that are going to support a U visa. A lot of times it's intimate violence, and so you might have a VAWA type case where that prostitute, sure that she's been convicted of it multiple times, but she's got the boyfriend, the husband, you know, whoever it might be, who is victimizing her also and abusing her and sticking her out there, or a parent who's doing it, whoever it might be. So just because you see this prostitution arrest, you should automatically be thinking as an immigration practitioner, okay, I know you've done this, let's mitigate this harm, but also let's look into what benefits might be out there, even if you don't want to necessarily tell me about it at our first meeting. So just, I would remember that. Okay, so then we move on to domestic violence. This is another area where I would say every female client who I have probably ever had, both in immigration and when I was a prosecutor, every female defendant and female client who got arrested for domestic violence probably had domestic violence issues and were the victim of domestic violence also. I saw this all the time as a prosecutor. Whenever the guy called the police on his wife, on his girlfriend or whatever, because she was abusing him and she got arrested, she would usually end up telling us at some point that he was abusing her, he was abusing the kids, you know, he was part of the problem. And so this is where we have a dovetail all the time of clients who also end up being victims. Mary, you look like you were going to say something. Sorry.
No, I'm just, I'm anxious and interested in getting to the Florida statute, and I'm wondering if that's the next slide.
Yeah,
Okay.
absolutely.
So there we have our touch or strike, simple battery. It's not going to be a crime of domestic violence, and it's not going to be a removable offense. I think we should go to the next slide.
Okay. Felony battery.
You're right. So there's two types of felony battery in Florida, right? There's the felony battery because it's been upgraded based on a prior. And then there's another felony battery when it's, as John would say, bad, bad, bad. So the straight felony battery, when it's based on a prior conviction for battery, is still not going to meet the federal definition of crime of violence because it doesn't involve the active use of violent physical force. In all types of violence genres, and whether or not it's an aggravated felony or it's going to meet the definition of crime of violence, we're looking for the active use of violent physical force, and a touch is not going to meet that definition. You want to go to the next slide?
Yep.
I think I'm stealing your topic, but here we have, you know, what a horrible statute, felony battery by strangulation. But then I talk to prosecutors and public defenders and they're like, yeah, you know, it happens. So here we are going to have a crime involving moral turpitude, an aggravated felony if you get a year or more in prison, and a domestic violence ground of removability. I have tried to argue, looking at subsection A and B, that it could have just been a touch, and that you don't necessarily engage in the active use of violent physical force, and I have lost. So this is a bad statute to agree to plead to if you can avoid it.
Right. I've seen this a lot in bloviating, and that's why Mary's trying to move me along. But I've seen it plenty of times where somebody is originally charged with something much more serious than this, like some sort of sexual battery, lewd battery, whatever it might be, and they plea out to felony battery because it's not a sex offense. You're not going to be a registered sex offender, but it's still going to be a huge problem.
Yeah, it has overlap in 3 different shoeboxes.
Right.
So I think there may be a waiver depending upon the facts. And again, it's going to be an aggravated felony depending upon the sentence. This is also a very bad, this is a very bad statute. So bad. Put that on your bulletin board. Bad.
That's right. So aggravated battery, same thing. Deadly weapon, not based upon the fact that the victim is pregnant, not based upon the fact that the victim is a school board official, firefighter, law enforcement officer. Those are bad things too. But if it's simple battery on a protected victim, that's not going to be nearly as immigration bad as aggravated battery with a deadly weapon or causing
That's a
serious
good
bodily harm.
point. Yep. Just because simple battery is upgraded based on the victim does not categorically turn it into an aggravated felony CIMT or crime of violence. And it's got to be, again, 18 USC section 16A, the elemental clause, crime of violence. You have to hit 16A, 18 USC 16A, in order to have a crime of domestic violence under the immigration statute. Child abuse. Okay, so I just got done, John, with a pretty big child abuse case.
Yep.
And I will tell you all the client, my client, this woman who was herself the victim of horrific domestic violence, just horrific daily abuse. A woman from the Caribbean, and a very humble person. And she immigrated here to be with her husband, and he beat the crap out of her weekly, if not daily. But he was also abusive towards the daughters. And she ended up withhold of adjudication, 1 count neglect, 1 count failure to report, and 1 count, hear me out, causing the child to become dependent. And if you look at the elements of those 3 statutes, John, you're going to see they're fairly innocuous. I mean, the neglect can be passive. It's not intentional. Failure to report, I mean, that sounds, not that bad. These are fairly passive crimes. And I argued that she was not removable for a crime involving domestic violence, and that she was not removable for a crime involving moral turpitude. And I lost, and I lost, and I lost, all 3 times 2. Now, it does look like I'm getting relief. The judge is working on a decision to grant her the domestic violence cancellation waiver. And we do have special waivers for victims of domestic violence. And I also argued, John, that she was entitled to the exception because she herself was a victim. So my client's going to be okay. But all 3 of those sort of passive crimes triggered removability.
Right. Yeah. So yeah, child abuse, child neglect, all of those areas are going to be a big problem. So then we move on to theft. We get into this area. We'll just cover that. The statute itself. You have it here, 812.014. So whether we're talking about grand theft, petty theft, grand theft auto, any types of these types of thefts, because our statute is written so broadly and encompasses so many things that we don't necessarily traditionally think of as theft, our Florida theft does not match the federal generic definition of theft. So even though you have an aggravated felony theft provision, which says if you're convicted of a theft offense plus 1 year imprisonment, you're an aggravated felon. In Florida, theft is categorically too broad, categorically includes things that are not common law and generic theft. So that's not going to be an offense that is either a CIMT or an aggravated felony theft offense. So we see this one all the time. And a lot of times we'll deal with somebody who's charged with both fraud and theft, and they pick the wrong one. They say, oh, I'll take the fraud because I'm not going to prison. I'm going to take the restitution order and the fraud, and then you end up with an aggravated felony, as opposed to if you had just taken the theft, no matter how much time you go to jail, it doesn't matter. Restitution order doesn't matter. You're not getting deported for that. So that's an interesting situation that comes up a lot. Yep. All right. Theft as an aggravated.
Theft and fraud can be sort of mixed and matched. Normally, you will want to plead to the theft. I guess we could sit and ponder and think of some situations where you might want to plead out to the fraud. If the loss was going to be less than $10,000, and then depending on what's going on in the criminal case, right, and the criminal arena, you might want to go with the fraud versus the theft. But for the most part, if you can drop a fraud and go with a conviction for theft, that's going to be a better solution.
Right.
Good stuff. Good stuff.
You got it. Theft is a CIMT. We get into that and we go on. Bad checks. Let's get into fraud offenses in general, bad checks and all that, Mary. You love fraud.
Wherever you have a specific intent to defraud, you're going to have a crime involving moral turpitude. And if the loss exceeds $10,000 to the victim, even if you're able to like get rid of the restitution order somehow, and do a side restitution or a civil restitution, immigration might find it, right? So even if the conviction record per se doesn't show a loss of $10,000, immigration will look for it. And then you're stuck making arguments about what that side payment or the, what do you call it when it's not restitution per se, but you have a forfeiture.
Forfeiture.
All right. Now there's a case wrongly decided that a forfeiture amount can represent the loss, which is not really true. I mean, there might be times when the forfeiture matches what the loss was, but that's not what a forfeiture is intended to be. A forfeiture is the disgorgement of ill-gotten gains. So if you made a profit off of crime, even if someone didn't suffer that loss amount, you pay a forfeiture. And we have this bad decision now that a forfeiture can represent the loss that we all have to deal with. Here you have 832.05. This first provision doesn't involve fraud, so it's not a crime of fraud. It's not a removable offense. But then you go to the next slide and you see another provision, subsection 3, that specifically involves an intent to defraud. And by pleading to 3 instead of 2, you're removable. Next slide. Oh, Medicaid, Medicare. I see a lot of that here in South Florida. It's out of control. I do not know, frankly. I'm going to take off my lawyer hat and just say, how do people defraud the government of like thousands and millions of dollars with these clinic schemes, Mercedes, Clínica Mercedes, with the little van. And now, John, they don't even just give milk and walkers to people who don't need it. They just get a list of social security numbers, and clients don't exist. They don't even have a brick and mortar location, and they're billing the government for just millions of dollars. But anyway, it's bad. Put it on your bulletin board. Crime involving moral turpitude. Usually Medicaid and Medicare fraud are going to be aggravated felonies because of the loss amounts. I do have a couple of tips on this screen. If you can avoid a conspiracy count and just plead straight up to something, that helps, because you don't want your client to be culpable in immigration court for the acts and the losses of co-conspirators. So if you can sever co-conspirators and not plead to conspiracy, that I think is a good idea. If you really do have a client who was the small guy on the totem pole, right, and really was just the receptionist at Clínica Mercedes, and is not attributable, a loss is not attributable to him or her, then you need to say on the record during the plea colloquy and the sentencing, my client is pleading, but they actually were only culpable for this amount, or they were not culpable for any specific loss, and get rid of the conspiracy.
Absolutely. All right, back to controlled substances. We talked briefly about simple possession of controlled substances earlier. This is the Saeed case. Alexis put the a link, I think, to the entire decision. Here's the publication, 28 Federal 4th, 1328. Love it, love it, love it. It was a wonderful decision. Use it across the board for all of your cannabis cases. So your cannabis offenses, 89313 is your simple possession. Like I said, anything on the Federal Register, you possess it in Florida, get convicted of it, withhold, or otherwise, you are in trouble. Then we got 89313, which is our sale, manufacture, delivery, possession with intent to sell, manufacture, deliver. Now, we have an 11th Circuit decision, which I think is completely wrong. Mary loves to disagree with the 11th. I just agree with them on this one, having been a state prosecutor who prosecuted these cases all the time, went to trial on them. The 11th Circuit said, oh, this is a divisible statute. These are all different crimes, and you have to prove each one separately, beyond a reasonable doubt. And therefore, these are all separate crimes that make up this particular statute. Well, that's not the case. We used to charge sale or deliver, possession with intent to sell or deliver. We charge it all. We just throw it out there, and the jury. You don't have to decide whether he actually sold it. If he delivered it for remuneration, whatever he did, you know, you don't even all have to agree on it. So we used to try this all the time, throw it all into one shoebox or one bucket and just try to get the conviction. The 11th Circuit said, nah, we think it's divisible. So where that leads to a problem is most people are not charged with simply just sale. It's sale or delivery or whatnot. What you want to avoid is the sale. What you want to avoid is the possession with intent to sell, because those are the two portions of the statute that are aggravated felonies, and drug-related aggravated felonies are super bad because of the fact that you can't waive them. So other types of aggravated felonies, you might be able to get a waiver for them if you can, you know, get a new green card, or you're coming into the US, you're one of those arriving aliens, you might be able to get a waiver for just a regular CIMT fraud-related ag felony, but you can't for this ag felony. So avoid sale, avoid possession with intent to sell, avoid all of that. And then, of course, we have trafficking, dun, 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 which is the worst of the worst, right? It's not, because the 11th Circuit, the same 11th Circuit who said, you know, sale and possession with intent to sell is an aggravated felony, said trafficking is not. Because as we all know, trafficking can be charged and convicted. You can be convicted of it for simply having way too much pot, way too much coke, you know, and it's not even that much, like 28 grams.
Mhm.
Yeah, so you want to avoid trafficking is safer than sale or delivery. Completely
Right.
counterintuitive, but absolutely true.
It's true. So trafficking is an example for those of you who are criminal defense lawyers and you can picture the statute in your mind, right? It's not divisible into separate parts. So the sale components are there with the straight possession, and straight possession is not going to be an aggravated felony. It's still going to be a controlled substance violation. This is not a free pass from removability unless it's marijuana, right? But the trafficking, we'll just say cocaine. If you are convicted of trafficking in cocaine, you are not going to have an aggravated felony. You're going to have a controlled substance violation, which is a different shoebox, but you're going to probably, especially if you're in an LPR, let's say not probably, let's say there's a good chance you're going to be eligible for relief. The sale, manufacture, delivery, you know, you want to ask the prosecutor, do you mind charging me with just delivery or just, you know, manufacture? Because that could be for your own personal use. And you want to avoid the verb sell. I have a lot of marijuana grow house cases, which now because of Syed are not going to be a problem. But prior to Syed, they were convicted marijuana grow house under 893.131, and they were usually charged with the whole statute, and that's a divisible statute. So I could win on the removability because I don't have the burden of proof, but then I would lose if I was seeking any kind of relief. Which
Right.
I would be because it's still a controlled substance violation. Woo, complicated. Love this stuff.
So much fun. All right, now we're moving into our final few slides and our final section. As we've already eaten up most of our time, we're going to talk a little bit about, okay, you've avoided a ground of removability, you've avoided a ground of inadmissibility. You're totally safe, right? Don't have to worry about anything else, and that's simply not true. So even if you know if your client is 212 or 237, there's also other issues involved. Are they from a TPS country? And there's a whole host of them, Venezuela, and you're dealing with Haiti, and you're dealing with Nepal and the South Sudan. You have all kinds of TPS countries out there where it doesn't matter if your client was convicted of a 212 or a 237 offense, because for TPS purposes, you might be dealing with someone who any two misdemeanors, no matter what they are, two no valid license convictions, and they lose TPS forever. You know, one DUI, one driving while license suspended at the same time, you lose TPS forever. And so you have to be super careful that depending on your client, you're not just dealing with 212 and 237. There could be other issues. DACA, the Dreamers, the DREAM Act kids, it's slightly different. You can have up to, not including, but 3 misdemeanors that are unrelated. You can lose your DACA. 1 felony or 1 serious misdemeanor, as defined by the regulation, can also bar you from DACA. So you've got a DREAM Act kid. You have to be looking out for those sort of things too. It's not just avoiding grounds of removability. And then good moral character. This comes into play in a variety of different things. Like we talked about, VAWA beneficiaries still have to establish good moral character. Citizenship, people with green cards still have to establish good moral character. And any arrest and any conviction can go against good moral character. Some of these arrests and convictions can lead directly to a bar to good moral character, and you can't even try to prove it. So these are all things you have to be looking out for. It's not just grounds of removability and inadmissibility. It's any arrest and any conviction can be a serious problem. DUI is one of those significant misdemeanors. You can lose DACA for it. It's very bad. You got 2 DUIs within a statutory period, and you can be barred from good moral character. These are all things you really need to be worrying about.
If you have a DUI and you're in immigration custody, but you're eligible for release, you're eligible for a bond, very hard to get out with a recent DUI. DUI is a discretionary factor that is taken into consideration by USCIS if they're giving permanent residency, by the American embassies if they're issuing a visa, and immigration judges will look at DUI if they're considering a waiver. And it is very often, believe it or not, the kiss of death. Significant negative factor whenever there's a discretionary benefit involved. Try to get it reduced to reckless driving. Even so, in the discretionary context, an adjudicator can look behind the record and see what it was that happened, but really don't assume that DUI is okay. It's not okay.
Yep, absolutely. Okay, and then our last slide, defenses and waivers. When you're dealing with VAWA victims, there is a built-in exception, and you don't even need a waiver necessarily for it. If you've got someone who's got a criminal history and you can link all of their criminal history to the abuse that they suffered, you simply have to prove it. You have to argue it, and you can have all of that criminal history forgiven as long as you can tie it back to the victimization. And so that's really important to remember for VAWA. For U's and T visas, who are people who are automatically victims by definition, there are waivers that are available for those visas for inadmissibility. So if you have a T or a U visa victim who has that prostitution conviction, I'm not saying it's a CIMT, Mary. I'm saying USCIS probably thinks it is, and you need a waiver, you can apply for that non-immigrant waiver. These non-immigrant waivers under Section 212D3 are pretty broad, expansive, humanitarian-based waivers. So you don't need the qualifying relative and the hardship that is required for other crime waivers. These are much more lenient and much more understanding waivers. Same thing for TPS. If you have a ground of inadmissibility for TPS, but you're still eligible because you only have one misdemeanor conviction that happens to make you inadmissible, same sort of waivers are available. So these I-192 is the form that you use. These are non-immigrant waivers, and they're very, very broad, and they take everything into consideration, including the victimization. Those are all things to remember for this. The only things that bar these types of waivers, just real quick, are, if your client happened to be a Nazi, probably unlikely, or they've engaged in genocide, torture, persecution, et cetera.
Terrorism, yeah. And you know what we don't have up here, and it's my fault, but we're remiss in not putting up battered spouse cancellation. So a big waiver that exists in the immigration law is generally in 2 parts. And one is for lawful permanent residents who've been convicted of crime, and they can apply for cancellation. Another is for non-permanent residents, undocumented people. They've been living here for more than 10 years. They have no criminal record, and they have children or parents who will suffer extreme hardship if they're not allowed to remain. That's cancellation of the removal, right? But in between those two is a melding, which is cancellation for victims of domestic violence, for battered spouses, and for parents of abused children, and for battered children. So it's a cancellation for the victims of abuse. And it can be that you're undocumented, or it can be that you're a lawful permanent resident. It's a very, very generous waiver. And even if you have been convicted of crime, you can qualify for battered spouse cancellation if you meet the definition at 237A7 that your crime can be tied to the fact that you yourself were victimized. So we could do a whole nother seminar. Maybe Alexis will ask us back just on relief when there is a criminal conviction. but we want you to know that no matter what, there's hope, right?
That's right. That's right.
So,
That's right.
I don't
So,
know if you want to look at some of these chats. Thank you so much. Thank you. John Guyon, good looking man. Yep, true.
said
Okay.
nobody.
Can you comment on synthetic marijuana, meaning convictions under synthetic marijuana laws? Haven't had one of those lately. I guess it's going to depend on whether or not the federal law has a similar definition of synthetic marijuana and it's considered a controlled substance violation. Oh,
That's right.
somebody answered. John Guyon answered.
John has been on it. He has answered, I think,
Ah.
everything in that chat. And I think maybe one came through the Q&A. Oh, no, that's gone. That one was gone, but now another thing came in. So I don't know if you want to look at those while I quickly put, first off, I want to put Mary's book in the chat because I think it's very important. You know, I think everyone here can see what experts we have on this panel. And I want to make sure that you have the resources to learn more from Mary, but I will certainly ask for you both to come back if you want to give more training, because this was absolutely amazing and absolutely brilliant. As someone even said in the chat, they used the word brilliant for you. So I don't mean to commandeer Mary, John, if you want to continue, I just wanted to post that book in there and make sure folks have it.
Thank you. I like to explain things. I think I explain them, you know, pretty carefully and walk people through it. And I enjoy doing it. I'm not going to become a millionaire on that book, but if I can save some people from unnecessary deportation and prolonged detention, then that's what it's really all about.
That's right. Thank you all very much, Alexis, for putting this together. It was absolutely amazing. Anytime you can put me on a panel with Mary, I will be here. She's awesome.
I will certainly take you up on that. I'm going to pop the CLE code into the chat.
The Italian version, the CLE.
The CLE. It is 2300639. N as in Nancy. I answered this in the chat as well, but I'll just put it out there. You will receive a copy of this recording and the CLE code in an email from Zoom. It'll come in 24 hours. It will not come from my direct email. It will come from Zoom. If that gets lost in your spam or something like that, I've put my email address in the chat a couple of times. Jot it down. Feel free to reach out to me. I'm happy to send it your way. Before we log off, and again, I hope I'm not interrupting you. You both just have an amazing bounce off of each other that I feel like the third wheel here. I just wanted to say, this training was amazing. I am partial as a former public defender when I was a baby public defender, and I'm running in court and trying to figure out everything for my Padilla and immigration for my client. Things move fast, and I wish I had this to look back on, or at least to get me prepared. So I want to thank you both very much. We are getting a question about the PowerPoint. I do believe that I'll be able to receive the PowerPoint and send it. I think that Mary mentioned that earlier.
Yeah, I'll send it to you.
Thank you so much, John.
And I just want to say thank you to everyone for all the good work that you're doing. Stay in the game, stay in the fight. It's worth it.
Absolutely. I couldn't agree more. So on that note, I'll leave it with Mary's last note. I hope you all have a fantastic day. Keep doing what you're doing. And John and Mary, thank you for everything that you do. This was awesome.
Bye, everybody. Thank you.
Have a good
Travel
day.
safe, Mary.
Thank you.